Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Today it's my pleasure to review a book by Robin Hollington. I've reviewed this book before. I met him some years ago at a book launch for one of the earlier editions. This edition is Hollington on Shareholders Rights, now in an 8th edition, written by Robin Hollington Queen's Counsel. It's part of the Sweet Maxwell THOMSON REUTERS titles which have been published. Elizabeth and I talked about this book, and for our review title we've said a 25th anniversary milestone for Hollington's definitive work on shareholders' rights, now in the new 8th edition from Sweet Maxwell. And I'll explain a little bit more about this in a minute. It's obviously a book for company law, corporate governance, whatever you want to call it, and minority shareholder rights. Let's have a look at the book. It's not a big book. It's a hardback, black cover. There's the front, spine. There's nothing on the back, but you see it's the 8th edition spine there. Now, what we have inside is the standard layout. The index is on paragraph numbering. You can see the index at the back. It runs to 400 pages, just over. You've got some very useful things. There's a nice, what's called legal taxonomy. Now, they do like to do this with Sweet Maxwell titles, and I'm very grateful. You've also got some very useful things. You've got a draft Tomlin order, for instance. Now, I find that quite helpful because when I'm drafting or when I'm with the client, I'm always trying to put my finger on somewhere where I can get this quite quickly. So it's nice to know that's at the back. That's in part of the precedents, which are at the back in Appendix 2. Appendix 1 covers draft regulation 119, exit rights. Let's go to the front of the book next. There's a nice little divider, so you can find things quite easily. It's a nice blue divider. And you've then got, there is the front page, and then you've got that's the basic information. The first book came out in 1990, so you can see that 25 years has gone by quite quickly. Then there's the preface to the 8th edition, where Robin is expressing, I think, a little bit of genuine wishful thinking of hoping someone will please help him take this on for the future, because it's such an important book. This is the forward to the 6th edition was by Mr. Justice David Richards, as he then was. Then you've got the 4th edition there. Then the 1st edition from Lord Hoffman. More about him in a minute. Then you've got the table of contents and detailed contents here. Rule and Foss and Harbottle features very heavily, of course, right at the beginning. Then the table, you've got a total of 14 chapters, and then the 2 appendices at the back. Then you've got the table of cases, and there are a lot of them, of course. Then statutes after that. Then some statutory instruments. Then you go into the main body text as a whole. You can see there's chapter 1. You've got the paragraph numbering on the side, and when you look at it, it's actually on the right hand side in this book, not on the left hand side. And then you've of course got footnotes, and of course the very first footnote, surprise surprise, is the case of Foss versus Harbottle. You can just go into the book and you can see it running all the way through. Now, probably some of you won't know what I'm talking about with this book, but we are talking about shareholders' rights. And we're talking about a problem which is actually quite an important one in terms of the way in which corporate governance operates in the 21st century, and that is trying to give some protection for the minority rights of shareholders when you've got a large number of people who have the majority shares. And really what we're looking for here is some indication of what you can and can't do. So let me say this right at the beginning. Hollington on Shareholders' Rights, this book here, has become a classic, no question about that, and it's now with the publication of the 8th edition from Sweet Maxwell. It's a title which retains its authority, erudition and verve throughout. There's no dry as dust law book about this title in my view, and as readers have come to expect, the new edition of Hollington both informs and delights with the more than occasional comment which you cannot resist at least a wry smile. So, which is nice to see, because some of these books can be a little bit po-faced, but this one isn't. And Robin's not that sort of guy. I mean, the fact is that this is a very user-friendly book, but it's dealing with an important area. We're talking about money, and it's dealing very much with the way the company is basically run, and the sort of protections hopefully given to those who are in the minority. And as did the first edition, which appeared in the 1990s, and subsequent editions since, the book deals fully and comprehensively with the law and the procedure of the remedies available, mainly to minority shareholders whose rights in the earlier history of company law were more than a little neglected. And it remains a great contribution, in my view, to corporate governance today. Now, says Robin Hollington in his preface to this edition, the law in this field appears to be approaching a state of relative maturity. The book therefore examines the most recent changes in the law as it continues to evolve, and furthermore points out that as shareholders' rights and directors' duties are intimately connected, the book's major task is to explore the duties of directors and the means by which they may be enforced. And therefore this subject emerges as one of considerable complexity, and in fact it really is, which the book, I think, tackles in a lucid, logical manner, starting with the broad principles at the beginning, which are those key principles which govern individual shareholder rights, and also what the author refers to as the balance of power between the majority and the minority. And please do bear in mind that there is no concept of democracy as we understand it in the same way between the minority and the majority. But do bear that in mind because of previous recommendations from inquiries over the decades. Now, subsequent chapters discuss in detail, in addition to directors' duties, such areas as majority rule and equitable constraints, unfair prejudice, winding up, personal rights of shareholders, and more. And there's a chapter on the foreign element, including the European dimension, and on miscellaneous rights, which cover, for example, a compulsory purchase in takeover bids. And I think the final word is on limited and limited liability partnerships, which deals with derivative claims and the rule in Foss and Harbottle, once referred to by Lord Hoffman, and I love this imagery, as a fire-breathing and possibly multi-headed dragon. And I think you should use that when you do your corporate law, company law exams. I certainly did in mine, and I did quite well. Now, bearing all this in mind, this new edition of Hollington offers important new perspectives and a fresh look at this important area of law, including such matters as the no conflict rule in this case of directors and the concept of enlightened shareholder value, enshrined, says the author, in the core duty of good faith owed by directors under the Companies Act 2006, which, as you know, is the main consolidating legislation, the largest piece of legislation we've ever had, in fact, so far. The courts, Robin goes on to say, the courts may not like being given the task of raising standards in the boardroom, but they have given the power, albeit limited, to do so. That's an interesting step forward because the courts have always been very reluctant to step in what are merely basically corporate matters where the court doesn't feel it has a jurisdiction or has a limited jurisdiction to act. And I think that's important because you're seeing slightly different approach perhaps towards corporate governance in the 21st century. So in short, this book, with its completely updated text and commentary, is a work of reference that no corporate lawyer or academic lawyer can afford to be without, especially with its extensive, that's over 30 pages, table of cases and tables of statutes and statutory instruments, plus of course the two appendices which are at the back. Now let me conclude by saying for the practitioner under pressure, navigation is sure and swift thanks to the detailed tables of contents, and they are quite full, numbered paragraphs and the lengthy index, which is again by paragraph numbering. You could certainly call this concise volume an indispensable addition to the practitioner's professional library for company law. That's what it is. Thank you, Robin. Thank you to everybody involved in this book, and the publication date is cited at 2017. Let's just have a quick look at it again. That's the front page. And this is Elements of Unfair Prejudice. Lots of cases. It's very well argued throughout. Brilliantly, a huge amount of work's gone into this. Very meticulous. You see the footnoting. There's not too much footnoting, you'll be pleased to hear. A lot of it is just to justify and give you further places to look. But I've been very impressed with the various volumes I've seen, editions rather, I've seen over the years. There's the index again, and you can see it's fairly concise. There's a lot of information, and then at the front you've got quite detailed tables of contents. Well, thank you very much indeed, and I do hope that we actually do get some more editions in the future. But I know Robin is looking for other people to help him out here, and the fact is there's a tremendous amount of learning that goes into these books. I'd like to thank you very much indeed, and all the other people involved in this, because this is where the law is for us, and it does make our lives easier having these books. So thank you. Bye-bye.